Good morning, folks. My name is Kim Rozak, and I'm here today with Brian Casaceli. And Brian and I are two of the 13 attorneys who are in the labor and employment group at Mirick O'Connell. Our group continues to grow, and we have lots of work because there's lots of new laws, and that's one of the reasons why it brings you here today. Mirick O'Connell is a full-service law firm, and we were established in 1916. Many of you know us from our annual labor and employment seminar that we have been hosting now for a number of years and are familiar with the attorneys in our group. But this morning, I just wanted to take a moment and introduce you to the other folks in the other practice areas at Mirick O'Connell, because I'm not sure how many of you have had the opportunity to work with our colleagues who, as I say, practice in a variety of specialties. And you may need to call on them in the future for the services that they provide. So I'm just going to take a short moment and tell you the breadth of the work that we do at Mirick O'Connell. We provide business and corporate work on behalf of management and businesses. We represent employers in connection with construction law, general contractors. Creditors' rights, bankruptcy and reorganization is another area of law that we provide services in. We also do work in family law and divorce, health law, general litigation, as maybe some of you do know, including personal injury litigation, public and municipal law, that's an area that I actually do work in as well, real estate, environmental law, and trusts and estates. We also specialize in servicing clients across industries such as the healthcare industry, higher education, life sciences, insurance, manufacturing, and technology. We also represent nonprofit organizations. I have several nonprofit clients. And this is just a tidbit of who we are. And importantly, what is always key to our relationship with our clients is we're here to listen, to advise, and represent in connection with litigation if it ever comes to that, which our role here is typically in our group, labor and employment, is to advise and counsel in a manner in which we can avoid that, but sometimes that's not avoidable. So without further ado, I want to kind of jump in to today's presentation. Katie, can you go to the first slide, please? On our screen, you can see we have the roadmap for today's webinar, and we will be discussing the American Rescue Plan Act, which was passed by President Biden in March of this year. Seems like it was passed years ago, or not years ago, but months ago, and it was really a month ago in a few days. We're all trying to digest it, but we're living with it. One more new law, as I said. And we will get into the tax credits for employers that continue to provide, or I should say choose to provide, emergency paid sick leave and emergency family and medical leave, consistent with the amendments to, well, I should say consistent with the Families First Coronavirus Response Act that was passed last year and was implemented through the end of the year, December 31st, 2020. And a new piece of law altogether under the American Rescue Plan Act is the Cobra Subsidies and the requirement to offer 100% paid Cobra coverage for certain employees who lose coverage between April 1st of this year and September 30th of this year. And we'll be getting into the details of that law a little later. And then at the end, Brian is going to turn our attention to the expected, not yet passed, but expected Massachusetts emergency COVID-19 sick leave law that has been discussed, and we have details on what has been agreed upon, but in our legislature. But again, that law has not been passed. So that will be towards the end of our presentation. So now, if we could have slide number 2, Katie. Brian is going to begin by talking about the status of the Families First Coronavirus Response Act, as I said, and then the options to continue with emergency paid sick leave and emergency FMLA.
Thank you, Kim. It's great to be here today with everybody, albeit under snowy circumstances. I do want to clear up two things that folks are probably wondering. First, that is an original Van Gogh hanging in my wall, not a $45 canvas from Wayfair. And two, Baby Yoda is back there. It was a gift from my colleagues. So in case folks are wondering, this moving to the actual presentation. So the status of the Families First Coronavirus Response Act. So as viewers know, that was passed last March and April, certainly in response to the blossoming pandemic at the time, and addressed a number of different areas. Two of those areas were to provide emergency paid sick leave and emergency family and medical leave to employees who were employed by employers that had fewer than 500 employees. That law, the Families First Coronavirus Response Act, expired on December 31st, 2020. In late December, President Trump signed a bill, however, that allowed employers who voluntarily continue to offer paid sick leave and family medical leave between January 1st, 2021 and March 31st, 2021 to take a 100% tax credit, certainly an incentive there to continue to offer the leave, even though there was no mandate to do so. Katie, would you jump to the next slide? Now, obviously, March 31st has come and gone, and we're in the middle of April. But prior to that time, prior to the expiration of that stopgap, that 3-month stopgap, on March 11th, President Biden signed into law the American Rescue Plan Act of 2021. Sort of sounds like a Bruce Springsteen song in some respects, and it does do a lot for the country. What it does not do, however, is it does not require employers to provide EPSL or EFMLA leave to employees. What it does do is incentivize employers to continue to voluntarily provide paid sick leave and family medical leave between a 6-month period that started on April 1st and which lasts until September 30th. And it does that by offering employers a 100% tax credit to covered employers. And again, a covered employer under the law is defined as an employer with fewer than 500 employees. Jump to the next slide, Katie. So what do you need to do to be eligible for the tax credit under that law? So first, you need to comply with all the provisions of the ARPA that were pulled from the Families First Coronavirus Response Act. One thing that is new to the ARPA is a non-discrimination rule. Specifically, employers must ensure that if they do elect to provide leave to employees under the ARPA, that they do not discriminate in how they provide the leave in favor of highly compensated employees, in favor of full-time employees, or based on employment tenure. So essentially, they're saying if you provide it, you got to provide it to everybody. You can't pick and choose. Jump to the next one, Katie. So one of the things that the Families First Coronavirus Response Act did is it provided 6 reasons for which employees could take leave if they were unable to work or telework. We've listed these 6 reasons on the next 2 slides. These are reasons for which employees can continue to take sick leave under the American Rescue Plan Act. But what the law did do is it added 3 new additional reasons for which employees can take sick leave. And Katie, if you jump to the next piece, they are listed as 7, 8, and 9. And everyone will recognize that their inclusion in the law is directly due to what's happened over the past 6 months and with the development of the vaccine and related side effects that individuals have experienced or may experience as a result of the vaccine. And I will say, I hope everyone, has had the opportunity to get that, and if not, can get it shortly if they want to. So the reasons for sick leave under the law that you can use it for If you're obtaining the vaccine, so if you're going to Gillette or Fenway when it was open, if you're recovering from an injury, a disability, an illness, or a condition related to the vaccine. I know there have been cases where some folks have experienced side effects for a day or so that maybe the result of the vaccine, and they would be entitled to take sick time for that. And the last one, not necessarily related to the vaccine, but still something that has been ongoing throughout the pandemic, is if the employee is seeking or awaiting the results of a COVID-19 test when the employee has been exposed to COVID-19, or the employer has requested the test in order to, for example, return to the workplace. Katie, you want to jump? So a few additional considerations regarding the paid sick leave. So first, if an employee had earned sick leave in a bank, in their paid sick leave bank prior to March 31st, that time does not carry over into April. That was forfeited. However, the law made clear that beginning on April 1st, 2021, employees were allowed and now are entitled to take 80 hours of earned paid sick leave. So even if they previously exhausted their 80 hours before under the Families First Coronavirus Response Act, they're entitled to an additional 80 hours beginning on April 1st. And like before with the Families First Coronavirus Response Act, employees who are taking their sick leave for one of reasons 1 through 4 and 6 through 9 on the prior slide should receive their full regular rate of pay, subject, of course, to the $500 and $511 per day limit, or $5,110 limit in the aggregate. So in addition to the paid sick leave piece, we also have the Emergency Family and Medical Leave Act. So under the Families First Coronavirus Response Act, employees were entitled to 12 weeks of leave under that law. Of the 12 weeks, however, the first 2 weeks were unpaid, and the remaining 10 weeks were paid at 2/3 of the employee's regular rate of pay, up to $200 per day. Under the American Rescue Plan Act, employees are entitled to up to 12 paid weeks of EFMLA leave, meaning that the first 10 days that were normally unpaid are now paid. So an employee is entitled to a full 12 weeks of paid leave. One thing that it's unclear about, and I've seen commentators taking different positions, is whether an employee who has exhausted his or her EFMLA leave prior to April 2021 is entitled to take additional EFMLA after April 1st, 2021. I've reviewed a fair amount of commentary on this, and it cuts both ways. Some are saying that, yes, it resets just like earned paid sick leave. Others are saying the statute doesn't specifically address it, and therefore it's not appropriate to read it into it. So I think we'll need to await further guidance from the Department of Labor on that piece. And I should note that we do expect further guidance from the DOL at some point, hopefully in the next few weeks, addressing some of these open-ended issues. One thing that we are fairly confident on is that employees who are working for employers covered by the FMLA, meaning that they have 50 or more employees within a 75-mile radius, are not eligible for the EFMLA if they have already exhausted their 12 weeks of leave under the FMLA. And then something else to note, under the ARPA, the expanded 12 weeks of paid EFMLA is in addition to the 80 hours of paid sick leave that an employee is entitled to, should the employer voluntarily offer these benefits to them. Katie, you want to jump? Thank you. Another thing with respect to the EFMLA is the reasons for which an employee may take leave has been expanded to include all of the reasons for which an employee may take earned paid sick leave, those 9 reasons. Before, an employee was only entitled to take leave under the EFMLA for when the employee's child's school or place of care was closed. Now, however, it has been expanded to include all of the other reasons for which an employee may take sick leave. Clearly, the intent behind the government's action was to make it as broad and expansive as it could for the benefit of workers. If an employee takes EFMLA, the employer can only take a tax credit of up to $200 per day and $12,000 in the aggregate. And before, it was $10,000 in the aggregate because the paid leave requirement only extended to 10 of the 12 weeks of eligibility for the leave. Now, because it's a full 12 weeks that can be paid, the tax credit increases to $12,000. And on the tax credits, they are taken against employer Medicare payroll taxes, and they're claimed on a quarterly basis. As just a quick aside, like the DOL, we expect the IRS to issue guidance on this with more specificity on how employers can claim the tax credits, assuming that they elect to provide these benefits to employees. So stay tuned for that, and we'll certainly incorporate an e-blast to get that information out to folks. And a refund may be claimed if the amount of the tax credit exceeds what the Medicare taxes the employer owes in a quarter. And again, IRS will pronounce rules on how to do that. And then, as I indicated before, that the law ends on September 30th, 2021. Therefore, tax credits, the ability to take a tax credit, likewise ends on September 30th, 2021 as well. And now I think I'm going to turn it back over to Kim for a discussion on the Cobra Subsidies piece. You're still on. Oh, there you go, Kim.
Glitch, not my fault. Not my fault. I actually clicked unmute 3 times, audience. Okay, so thank you very much, Brian. On to a piece of the American Rescue Plan Act that is entirely new to all of us. Now, if you don't have enough responsibility and you're not paying for enough things, employers out there, you got one more thing to pay for: Cobra Subsidies. So the American Rescue Plan Act requires employers and sometimes group health plans to offer 100% subsidized continuation coverage to, and the term is assistance eligible individuals, as you'll see that's in quotes there because that is a term that's defined, between April 1 and September 30th, 2021. Katie, you're ahead of me. Thank you. So before we get into, the obligation to provide for subsidies to employees during this time frame, I just want to give everyone a quick refresher on what is Cobra. I'm sure you all know what it is, but as a reminder, the Consolidated Omnibus Budget Reconciliation Act provides a temporary continuation of group health insurance coverage for qualified beneficiaries that would otherwise be lost due to a qualifying event. So you can continue healthcare coverage, you can continue dental, and you can continue vision coverage. You can continue if you're the employee, you can continue if you are, as it says there in the bullet point, a qualified beneficiary. So it could be a spouse, could be former spouse through divorce agreements, children. A qualified beneficiary is an individual who had been covered by a group health plan on the day before the qualifying event occurred. What's the qualifying event? Well, under Cobra, the qualifying event would be when the employee loses his or her health insurance because of a termination. Now, just want to kind of highlight here, under Cobra, as our original Cobra statute provides, it's the termination for any reason. So you get Cobra, regular Cobra, when you voluntarily separate from employment. You're offered the opportunity to continue health insurance. That's going to be different under the subsidy, so I want to highlight that piece. So under ordinary Cobra, I guess what I'll call that, termination for any reason you qualify other than for gross misconduct. That provision also continues in the subsidy. You won't be allowed to get subsidized if you are terminated for gross misconduct. And the other big group, or the other big reason why you would qualify for Cobra, is if your hours are reduced and go below the limit required for coverage. You know, typically employers have a minimum of maybe 15 to 20 hours a week. You must be regularly employed and working for those hours to be covered. If you go below that, then you're eligible for Cobra. Katie, can you turn to the next slide? Cobra does not require, as you know, employers to pay for continued coverage. That's the obligation of the employee. And under Cobra, an employee is required to pay the full amount of both what they were paying for health insurance before, along with the employer share. And ordinarily, there's a 2% administration charge on top of the 100%. So I don't know, I mean, out in the employer world, all I do is give advice. I don't actually pay a lot of attention to whether clients say to me, yeah, we have a lot of people on Cobra or not. My understanding is not a lot of people elect Cobra, or if they do, it's usually for a small period of time to bridge until they either get a new job, they get onto their spouse's plan, or they find, you know, a much less expensive plan. So Cobra is it's certainly an important option, but not one that's exercised a lot because it's very expensive. In the second bullet point on the slide here, it reminds us that the coverage under Cobra must be identical to the coverage that the employee or the beneficiaries were getting under the health plan originally when employee was employed. Next slide. Cobra here, it says generally applies to all group health plans maintained by employers that had at least 20 employees. So I'll just, you know, explain here for a second. Sometimes you'll see in materials like federal Cobra, and you think to yourself, Cobra is a federal law, so why are they calling it federal Cobra? Federal Cobra is the law that applies to workplaces that have at least 20 employees. Because if you don't, then you're not really offering Cobra. It's what we call, in the second bullet there, mini Cobra. So in Massachusetts, we do have a mini Cobra law that applies to employers that have employees that have between 2 and 19 employees. So that's the mini Cobra law. The distinction there is that's the state versus the federal. Katie, next slide. So now we're going to turn to the American Rescue Plan Act. So the law here applies to all employers that are subject to Cobra. So in this instance, meaning the federal Cobra, as well as employers who are not subject to Cobra, but maintain the benefits according to the mini Cobra law in Massachusetts. So you've got this federal law applying to, I'm going to call it again, federal Cobra, as well as mini Cobra in Massachusetts. And the ARPA requires employers and group health plans to offer 100% subsidized continuation coverage to assistance eligible individuals who are qualified here between April 1 and September 30th, 2021. So for people who have been terminated or their hours go below the threshold for maintaining employment, for maintaining health insurance, excuse me, they'll be eligible for the subsidy. Next slide. A little bit more detail here on who qualifies for the Cobra subsidy. An assistance eligible individual is someone who loses or has lost already their group health insurance due to an involuntary termination. So as I said, I want to highlight again, these are only involuntary terminations. Again, gross misconduct does not require you to be paying for somebody's Cobra. Reduction of hours, again, qualifies. And it has to be someone who elects Cobra between April 1 and September 30th, 2021. Now, importantly, who is not an assistance eligible individual? Those would be folks who are eligible for another group health plan, typically through either a spouse's plan or a new employer, or if the employee or former employee is eligible for Medicare. So if you've got those three conditions that would disqualify an individual from being able to get that 100% paid Cobra subsidy. And again, I'll go over it. You get new employment, you are eligible to get it through a spouse or Medicare. And I think what's important here is, and I have read on this, I originally wondered if, say the spouse is not originally carrying the benefit because it's much less, either the plan isn't as good of a plan, doesn't cover as much, or the spouse has to pay considerably more towards the health insurance. So naturally, you're going to have a situation where you choose the benefit that's the more advantageous to you, meaning my employer has a better plan and my employer pays more money towards it. Now you have lost coverage and you're eligible for a subsidy, and you think, well, I'd rather get the 100% paid through Cobra for 6 months and then maybe go on to my spouse's plan. But it doesn't matter how much more the spouse plan cost or how you view the plan as being less advantageous. If you're eligible for coverage through a spouse's plan, you will not be eligible for the subsidy. So the employer will not have to pay. Next slide, Katie. In addition, individuals who suffered a qualifying event before April 1, 2021, and who didn't elect Cobra before, will be eligible for the subsidy period so long as their entire Cobra period hasn't passed yet. So keep in mind that generally speaking, Cobra is available to employees, former employees, for a period of 18 months. So if this 6-month window of April 1 to September 30th occurs while there's any time left on that 18-month time frame, that individual who became eligible for Cobra, and I think it's as early as November of 2019, because from November 2019 looking forward would bring us over the course of the 18 months into the month of April this year, for which they could be eligible for at least a month worth of the benefit paid. So you have to consider the fact that it's not just applicable to people who have lost their health coverage beginning April 1, but as far back as November of 2019. And of course, that date is going to roll as we move forward into the 6-month period. I made a note to myself here on the slide that I wanted to cover this as well. So you could have a situation where folks lost coverage, we'll say, January of last year or February, March, something like that. They still have, time available on their 18 months. They come within the period of April 1 to September 30th. So there's some amount of time for which they could be receiving the subsidy. But they went ahead and they got alternate coverage, not through Cobra, because that was too expensive for them. So even though their Cobra date occurred, we'll say last year, and as I said, January, February, March, something like that, they didn't get Cobra. But what they did is they went to the health insurance marketplace. So under Obamacare, the Affordable Care Act, they went out and they got themselves a health insurance plan that's federally subsidized, and that does require some income requirements to meet in order to be eligible for that. But the person did that, or the person was eligible for Medicaid, not Medicare, but Medicaid. And they've been on that kind of, Medicaid or an alternative health insurance plan. Those folks can jump off those policies and be subsidized under the Cobra subsidy here for as many months as are left on their Cobra 18-month period, we'll say. So I want to keep that in mind, that you will have a category of employees who may be covered under some other insurance right now, can jump off that plan and be subsidized by the employer. Next slide. So like everything else, there are notification requirements. Cobra, as you know, has a requirement that notice be provided to employees. During this special time frame here, April to September 30th, 2021, there's different notice that's going to go out. So employers and their insurers are required to notify individuals who are eligible for this Cobra continuation coverage under the American Rescue Plan Act. And the notice must be provided in the regular course if you're separated here between, as I say, April 1 and September 30th. The plan administrator must notify the individual within 14 days of the qualifying event of their eligibility for Cobra. So that's sort of, again, the usual notice. I think the notice is slightly different in that it talks about the subsidy, but the timing of it and when it occurs is going to be the same as your regular Cobra up to this point in time. But there's a different notice. So for those individuals who were separated earlier, but still on the 18-month time frame that would bring them into April 1 up to September 30th. So for those individuals who experienced their qualifying event before April 1 and either did not elect Cobra or elected it and no longer have it but are still eligible, they must receive notice of their right to elect Cobra coverage by May 31st, 2021. So you out there may think, how am I going to know who that is? How do I know if they had coverage? I don't know if they didn't have coverage. How would I know if they are got coverage on Medicare, can drop it and join, a subsidy, the subsidy program, I'll call it. Our advice is going to be that what you do is you take a look at all of the employees who have been separated up to, going back 18 months prior to April 1 of 2021. And see, if they're going to be eligible for a day. I mean, I think you have to send the notice. Being more cautious and risk averse here is the right thing to do, because you're not going to get people trying to get coverage for a day. I mean, it may get people seeking coverage for a month, but I would recommend that you go back in time and you try to capture all of the separations. The other thing that you're going to need to do is determine whether they were involuntary. So if they're solely voluntary and they left on their own, that's fine. I have not seen this in the literature, but I'm assuming that people who voluntarily drop hours so that they are now, have lost health coverage, that would be the same as a voluntary termination and they wouldn't be eligible for the subsidy. So if you had somebody who was working 30 hours and felt that they wanted to cut down to 15, making them ineligible for health insurance, if that was a voluntary decision, then they're not going to be eligible for the subsidy. But you need to make sure that you're capturing the people who are involuntarily terminated or whose hours were reduced. And then you need to send them this new notice. And I think on the slides, yes, on the next slide, Katie, we can go to the next slide. Brian has here on our slides, it's actually an active link, but that would be the link to the model notices. I think I probably should mention it here so I don't forget, although people might ask the question. What do you do about individuals who were separated during the 18-month time frame that covers April 1 to September 30th? And they were incentivized to leave, shall we say? They resigned in lieu of termination. That's an open question as to how you would interpret whether they were involuntarily separated or not. I would again err on the side of caution. And if there were separation agreements that provided people severance, that the separation agreement characterizes the termination as a resignation, let's be honest, if the only reason the person resigned is because they knew they would otherwise have been terminated, I would say that under the law, they're going to be eligible for the subsidy. Again, open question. I haven't seen that particular issue addressed with a definitive answer. I've seen it raised in the literature, but not answered directly. But as I say, I certainly recommend that individuals that fall into that category should be treated as an involuntary separation. On the slide here, what should the notice contain? As the slide states, the Department of Labor has released these model notices that need to be provided to the assistance eligible individuals. They differ depending on when the qualifying event occurred, and that I mean by that is whether it's before or after April 1, 2021. And also, again, employees or employers subject to the mini Cobra law have the same obligation. Next slide. So after providing notice, are you all done? Done with this law? Not yet. Not yet. Employers are required to provide what is known as an expiration of subsidy notice. So you're alerting people that their subsidized Cobra coverage is going to expire on a specific date. So again, if somebody is separated beginning now, they're going to be eligible to get the benefit all the way to September 30th. But if someone was separated before April 1, they wouldn't be able to get the benefit all the way to September 30th. So you're going to have to let that individual know when their Cobra coverage, subsidy coverage is going to end. Notice should be provided no later than 15 days before the expiration, but not earlier than 45 days before. And notice, however, is not required if the individual becomes eligible for other insurance coverage or Medicare. So again, that would be if they're eligible because they've got a new position that offers health insurance, a spouse, they're going to join the spouse plan, or Medicare. So if the individual is the one who's getting off of it and they're making the decision, you certainly are not obligated to let them know that their coverage is going to expire. They are supposed to be letting you know that they have become eligible for other health insurance. So what does the employer get for doing all of this? Like, why are we paying for this, and how are we paying, and what do we get in exchange for that? So employers may claim reimbursement for the subsidies that they're paying in the form of a payroll tax credit against the employer's share of the Medicare tax. Okay, and for fully insured health plans that are not subject to federal Cobra, so those are like government plans or church plan, and the employers that are subject to mini Cobra, it's the insurer that's eligible for the tax credit because it's the insurer that's supposed to be paying the subsidy. So I'm going to say that again. For fully insured health plans not subject to federal Cobra, the insurer is the party eligible for the tax credit. All other instances, because it's like most of the time, folks, it's the employer that's going to be responsible for paying the subsidy. And if the employer pays the subsidy, then the employer gets the tax credit or is eligible for the tax credit. So that kind of gets us through the Cobra piece of things. I'm going to guess that we probably have some questions on that. Why don't we do this? I think we'll turn to the expected Massachusetts emergency COVID sick time law. Have Brian speak on that, get us through that, and then we can go to the questions. So if everyone is a little bit patient, we'll get to one more topic and then we'll do Q&A. Thank you.
Great,
Brian?
thank you. Thanks, Kim. And just to reiterate what Kim had mentioned, we'll take questions certainly at the end, and to the extent that we can't get everything in there, and I know there's been a lot of great questions coming in, we'll certainly follow up with you after the fact and make sure you get an answer to your question. Just want to end on a state level note. So the legislation we discussed thus far was enacted by Congress. There's something important that everyone should be aware of that's currently being considered at the State House, Beacon Hill, and that's Massachusetts emergency COVID sick time. Now, as Kim mentioned at the outset, and the reason why I have an asterisk next to the heading is that this is a proposed bill. It has not been signed by Governor Baker due to disagreements, some of them are significant, with the legislature over certain aspects. And I'll touch on those briefly in a bit. For that reason, imminent resolution appears unlikely. I'm sure employers are aware that Beacon Hill is currently trying to figure out an issue as to the insolvency and the unemployment fund, and a lot of employers' unemployment taxes have gone up significantly and quickly, and so they're trying to come up with a fix for that, and then probably we'll move to the sick time piece. And then the last thing I'll just note here is that while what I'm about to say is not an exhaustive summary, it will circulate an e-blast as we do, if and when the bill becomes law, with all the details for folks. But I'll tell you what we know at this point and what's likely to come about. So you can jump, Katie. Thank you. So 10 days after the law takes effect, all Massachusetts employers would be required to provide COVID-19 emergency paid sick leave. Another thing that you have to worry about as an organization, as if you don't already have enough to worry about. Jump to next slide. So I won't go through all of these reasons why an employee can take paid sick leave under the Massachusetts law. I'll let you all do that in the interest of time. What I will say, though, is that if you go through them, you'll notice that many of the reasons why you can take leave mirror the provisions provided under the ARPA, which came from the Families First Coronavirus Response Act. So there are a lot of similarities between these two laws. You can jump this slide, Katie, and then the next one too. We'll let folks take a look through those at their convenience. So another agreed provision. So under the bill, an employee, if they want to take sick leave, must notify his or her employer of the need for their leave as soon as practical or foreseeable. That language is also from the Families First Coronavirus Response Act and the ARPA. After the first workday, the employee receives leave, the employer can require the employee to follow its reasonable notice procedures that they may have in place for other types of leave. For example, the master and sick time or a vacation policy or an absence policy that they may have in play. And in most cases, the notices in those policies would pass muster for the reasonableness requirement. The last thing too on this slide, the legislature and the governor appear to agree on the fact that the leave can be used on an intermittent basis and it can be taken in hourly increments. So it will certainly be important to track that time if it is used in increments or an hourly or used on an intermittent basis or in hourly increments to ensure that employees are entitled to use everything to which they are owed. Next slide, Katie, explains what or how much leave that they are entitled to. And that's going to depend entirely on their work schedule. So if you're a full-time employee, you're working 40 hours or more per week, you're entitled to 40 hours of leave. If you're working less than 40 hours per week, but you're maintaining a regular schedule with consistent hours, you're going to be allotted an amount equal to the number of hours that you work, as the employee works, over, on average over a 2-week period. And that will certainly require calculations on the employer's part to identify what that allotment might be. The same is true for the two situations on the next slide, which address circumstances. Katie, you can jump. Address circumstances where, unlike the prior two, the workers' hours vary week to week, and the schedule can be unpredictable. In that case, you're going to have to look back for the past 6 months and determine what they were scheduled to work per week, and then from those numbers identify what an average of what they worked, and that would be what they would be entitled to. And again, a further wrinkle, if they didn't work 6 months, they would be entitled to take what they would have reasonably expected to believe that they would be normally scheduled to work over that period. So again, calculations that unfortunately need to be done to determine what employees may use. And on the next slide, Katie, posting requirements really is consistent with every law that we see nowadays. An employer has an obligation to inform its employees about the law. So within 7 days after the law becomes effective, employers are required to post a notice about the law in a conspicuous location at the physical premises. Obviously, with significant parts of the workforce remaining remote, they can accomplish that same mandate by sending the information or the notice via electronic communication, so email, or by posting it on a company intranet, for example. And I expect, and I think it's in the legislature's proposal, that there will be a model notice prepared, as in most cases. So we'll certainly include that in any e-blast that we provide. Now, right, so here's what's left to be ironed out. And as you can see, there's a lot. So when the governor rejected the legislature's proposal for the earned sick time, he sent back a number of amendments that he would like to see incorporated. And those are laid out here. I know in the interest of time, I won't spend a ton of time because, again, there's been no agreement, but the amount of compensation that's paid during the leave, the governor's proposal said that it would be similar to the Families First Coronavirus Response Act, where the amount of leave that you would receive would be dependent upon the reason for which you're taking the leave. Legislature said, nope, you should be entitled to the same amount regardless of the reason. Reimbursement or tax credit. So this is different than the ARPA in that employers who employ 500 or more employees would be entitled to either reimbursement for the time provided under this law or a tax credit. It's the legislature's position that eligible employers should apply for a reimbursement from a fund that the state will set up to fund this program, whereas Governor Baker says no, employers should receive a $40 tax credit for each employee that, whether or not the employee takes leave under the law. So that needs to be worked out too. Whether the leave would be reduced by other job protected leave. So Governor Baker says if you're providing ARPA leave, that your mass earned sick time leave should be reduced by that amount. Legislature says no, it should be in addition to, so you get both. You can stack one on top of the other. The end date, the legislature proposed 3 different possible options. One, if the funds run out, for which employers could be reimbursed. 2, if the entity overseeing the fund sends a letter to employers saying it reasonably expects the funds to be depleted by a certain day. Or 3, September 30th. The earlier of those 3 events would be when the leave requirement would end. Governor Baker says, nope, let's just say it ends on September 30th. And then the last thing is the definition of employer. I don't know if we have, I think I saw Marie Casey, who's from Hopkinton, on here. So this is important for municipalities. The legislature's initial proposal included municipalities in the definition of employer, so they would be required to provide leave. However, Governor Baker, with the blessing of the Mass Municipal Association, indicated that, or tried to exempt, or is trying to exclude municipalities from the coverage requirement, indicating that many, as Kim well knows, many municipalities are highly unionized and are provided significant benefits there. Therefore, there's no need for an additional amount of paid sick leave to their employees. With that said, that concludes our presentation. We will take some questions, and again, in the interest of time, what we'll do is I think Katie's going to download the questions and then send them to Kim and I. And if we don't answer them now, we will certainly get back to you before we do have your contact info. Kim, is there anything in there that you wanted to touch on Cobra? And then I see a few on there that I can address as well.
There's not so many questions, Brian, that I think we may be able to get through them with some efficiency.
Okay.
If folks are tolerant of that, we can move right through them. First question I see is, does all of what you just covered only apply to companies with greater than 50 employees? I think that meant 500. And I think because the question was raised at 10:24, it goes to Brian's question. So
Yeah.
Brian, I'll let you answer that
Sure,
one.
sure. So the law would apply to employers with fewer than 500 employees, but who voluntarily elect to provide the leave. So there's no mandate, but if you do, decide to apply and use the mandate, use the leave for your employees, then you would be required to comply with the requirements, and you would be entitled to a tax credit for the leave under those basis.
The next question looks like one that you may be able to answer quickly as well.
Sure.
Ryan.
I understand. This is from Jonathan Menina at Community Aid. I understand it's unclear whether an employee, however, is it clear that if they used a portion of the 12 weeks before April 1st, they can now use the remaining allotment? I think that would be okay. I don't know, Kim, if you have any.
Yeah, I wholly
Yeah.
agree with that. Absolutely. Yeah.
Yeah.
I would say for sure.
From Leslie, do you know if backup is required from employees to show proof of vaccine? So it's unclear at this point. There's been no guidance. What I would say, though, is I think that it's fair to assume that it would be okay to request backup. And I say that because in the original Families First Coronavirus Response Act, there was a listing of documentation that employers were required to obtain in order to receive the tax credit. So I think that it would, I don't have any definitive guidance on that, but my sense is that proof of a vaccine would be something that the DOL would consider, asking folks to obtain. And, at this day, proof of the vaccine is the card that you receive. Kim, do you have any thoughts on that? Anything different?
No, and I would agree with you. And I think, you can certainly ask for it, because I had that question raised when I was discussing whether employers can require the vaccine. And while there may be some trappings of information you receive about folks' background if you administer vaccines on site,
Right.
The pre-vaccine questions, the qualifying questions, screening questions, I guess is the right word. You don't get any information. You don't get any medical information from someone who just provides you the proof of the vaccine card. So I agree with Brian. I think that's fine.
Katie forwarded me a direct question that was forwarded to her, and I have to confess I need to get back to it. So if an employer has a PPP loan, are the employees still eligible to take EFML leave under ARPA and FFCRA? I will follow up on that. Kim, do you know the answer to that off the?
What is the question?
So sure, and so if an
I think I see it. If my company got, you mean if my company got a PPP loan?
Yeah.
Does this impact any of these laws? I
got to follow up on that because I did see some provisions in there about double dipping, but
yeah,
I don't know.
Right. You are not allowed to double dip for this period of time.
Right.
So my answer is going to be this: if the company is volunteering to provide this additional benefit of earned paid sick leave under the rescue plan and or the emergency family and medical leave under the rescue plan, your PPP loan was for a different time frame. Unless you applied for the second round and got it, or in the process of getting it for that. But if your PPP loan from before covers the 2020 year, you're not double dipping, because the ability to offer the benefit now covers the present time, and you would be taking tax credits against the wages paid now, not previously. So that's my answer on that one. I know there were a couple of Cobra ones I might be able to touch quickly. And I think I confused people when I said federal Cobra. What's the difference between federal Cobra and mini Cobra? Federal Cobra is just the Cobra law that applies to employers with 20 or more employees, because the federal law does not apply to workplaces that have 19 or fewer employees. The only law that would cover it is if you have a state law. And in Massachusetts, we do have a state law, and that's called the mini Cobra law. So mini Cobra is the state law that covers employers that have between 2 and 19 employees. Federal Cobra kicks in at the 20 employee threshold. Another question, does the subsidies issue, does this mean that people who voluntarily resigned are not eligible? Answer, correct. They voluntarily resigned, they don't get the subsidy. Question, is Mass Health considered an other group health plan? I'm going to assume it is. Some of these questions may be better asked to your insurance provider, but my understanding is that Mass Health is an other group health plan.
And I agree, Kim, and I think I would also note that the law makes clear that if you are eligible for Medicare, then you are not eligible for a Cobra subsidy, and I think Mass Health would take a similar, is a similar entity to Medicare, just on the state level. So, but we can follow up on that.
Yeah, this is a very good question that somebody raised. Does the family of an employee that passes away qualify as, the eligible people, ARPAs, for the Cobra subsidy? So in other words, you're in the unlucky situation where the person in your family who's carrying the insurance dies. Something? I'm going to say no. I haven't seen this anywhere, shockingly enough. And the reason I say that is because I'm thinking that the American Rescue Plan Act and the subsidies that come under it are largely the product of attempting to assist people who continue to lose their jobs as a result of the pandemic. Clearly, it's not tied directly to that, but economic losses and things of that nature. And as a result, the employer needs to separate people. So people, are terminated. I've never considered an employee that died to have been involuntarily terminated. So that's the reason why I think the family of an employee that passes away is not going to be eligible for the subsidy. Ryan, what do you think about that?
I tend to agree. Yeah, it's another one we can follow up on, but I think your analysis, Kim, makes sense.
I haven't seen that anywhere addressed in the literature.
Yeah.
Another question is whether the subsidy only applies to the employer share, or is it the whole premium? It's the whole premium. The whole premium.
I think, I don't know if we answered this one. If an employee reduced hours and went on their spouse's plan, would Cobra need to be offered by us because reduced hours are due to COVID? I think the answer to that is no, because they're eligible for another health plan. And I think the literature makes clear that eligibility to go on a spouse's health plan would preclude the Cobra subsidies. Is that your understanding too, Kim?
Yep, okay. Absolutely, yep. So people are asking to get a copy of the slide deck. That's absolutely available, right? Katie, you can do that for us.
How would this work with workers' compensation? It's a good question. So if an employee is collecting workers' comp due to a COVID-related illness, are they eligible for EPSL?
Well, you know what I'm going to guess? If it's proven and established that the workers' comp claim is as a result of exposure on site, which is a hurdle in and of itself, but let's just go there and make that assumption, right? Typically, an employer may have a policy that allows folks who are on workers' comp to use the delta, right, between their workers' comp and 100% of their pay, sick leave or vacation, whatever, you can supplement, right? employers allow that. If you want to collect 100% while you're on workers' comp and you've got some paid benefits, go for it. Brian, I swear I have to ask you, I know that there was the prohibitions under the FFCRA for supplementing some of these benefits. You had to use the whole thing.
I think you could supplement to full salary, but you can only take a tax credit for the amount that was allotted to you.
Okay.
I think that's what my understanding of the law was. It's a great question.
So I'm assuming if you could supplement using FFCRA benefits previously, when an employee was on workers' comp for, exposure to COVID or as a result of the workplace, then I guarantee you can, because it's the same benefit, only it's just simply there's certain trappings that Brian explained that this is a little different, that's different, but
right.
The law, the gravamen of the law is still the same, and it's really the difference is that it's voluntary now and not mandatory. So if you could do it before, I'm confident you could do it now. I'm not really able to answer whether you could do it before. I assume you could. I don't know, Brian, maybe that one requires a little bit more.
Yeah, we can take a look. I can take a look for sure.
Kathy Goulet points out aptly that this is all a nightmare. I couldn't agree more. And if anyone has suggestions for tracking all of this, Excel spreadsheets, folks. Oh, and somebody suggested, yep, thank you.
Looks like that's it.
All right. Okay. Thank you so much, folks. We should have some sort of contest. This is just me now going rogue, I'm sorry, but it is Friday, and the contest could have been based on, if we were all able to do this earlier, who is in the location with the most amount of snow? I'm looking out my window, and I can guarantee you we've got at least, well, I'm gonna be fair and say 3 inches, but anyway.
I'm in Barbados, so there's no snow here.
Yeah.
Terrific.
Thank you, everyone. We really appreciate
thank you so much.
your time and attention today, and we're here for questions you have on other matters, as you know. Thanks so much. Have a great weekend.